Kia ora, my name is Eden and I work at Community Law South Auckland. Today I'll be doing a legal education session on alcohol interlock sentences. I thought this would be a good topic to cover because I see this quite a bit at our mahi where someone has been sentenced to an alcohol interlock sentence, but they don't have a car to be fitted with an alcohol interlock device, and then they get stuck in this cycle of being between a rock and a hard place and not able to get a new license that will move them forward. Essentially, an alcohol interlock sentence is mandatory when there is a qualifying drink driving offence, the offender has a previous qualifying alcohol conviction within 5 years, or the alcohol reading is high enough to trigger the interlock regime even as a first offender. So typically you see this with drink driving when alcohol interlock sentence is imposed. So the breath reading, the limit for adults is 250 micrograms per breath. 0 to 250, that's fine, you don't get any in trouble. If you're between 250 to 400, you can get an infringement, which is just a fine. If you're over 400, then you are straight to court, unfortunately, for a drink driving offence, which can lead to a conviction. So if you've had 2 drink driving instances within a 5-year period, then you will be subject to the alcohol interlock device. If you have blown over 800, which is nearly 4 times the legal limit, then you're automatically subject to the alcohol interlock device, even if it's your first offence. So those are the typical situations we see. The judge does not have a broad discretion to simply substitute an ordinary disqualification, because that's a situation, your first time drink driving offence and you blow 650, you'll be subject to a 6 months mandatory disqualification, as when you hit that 800 that you're subject to the alcohol interlock device. Some people prefer the alcohol interlock device because it allows them to still drive, which is with the alcohol interlock device fitted, which means that they have to blow into it every single time they drive. It has to be 0 alcohol for them to be able to start the vehicle. The issue with that is that it costs. So different providers offer the regime, but roughly it's about $2,000 for the year, because you're subject to an alcohol interlock sentence generally for a year. So there's monthly payments you have to pay, and obviously to pay for it to be installed and pay for it to be taken out at the end of your sentence. But yeah, so it does cost, it does allow you to drive, but that's not suitable for a lot of people. So an alcohol interlock sentence usually involves a minimum 28-day disqualification period after the person may apply for an interlock license, and they may only drive vehicles fitted with an approved alcohol interlock, and they generally must complete at least 12 months of compliant interlock use before becoming eligible for a 0 alcohol license, which lasts for about 3 years after the alcohol interlock. So it's pretty burdensome. You get 28 days stand down, then you get a year of the alcohol interlock device, and then you get 3 years of the 0 alcohol license. Then you can get your license back after that. So it's quite long, and that's why always best to just be careful and just probably avoid alcohol completely if you're driving, because you never know what the levels are going to be like, and everyone is different. There's a common misconception that time alone satisfies a sentence, and it does not. If a person installs an alcohol interlock device, they generally remain stuck in the alcohol interlock stage and cannot progress to a 0 alcohol license. This is the issue I do see quite often, is that someone has come like a couple of years later, they've got the alcohol interlock sentence, they were never told they were meant to install the alcohol interlock sentence for it to run, so they've been on this alcohol interlock sentence for 2 years, far longer than what their sentence was, and they want to start going through the 0 alcohol interlock license, the 0 alcohol license. But the thing is with that is that the sentence hasn't even started because they have never installed it, and this is why some people get confused by it, or this probably not advised properly by if you've got a duty lawyer. But basically you have to start installing it, and then it starts running. So everyone should be mindful. That's the most important point, is that if your alcohol interlock sentence, get it installed, or you don't even start it. Whereas in difference to that is a disqualification. It's to start straight away, you don't have to do anything. The disqualification would just run for that 6 months. And once that 6 months is done, then you're back able to get your license back. So that's why this is much more burdensome. But again, some people would prefer the alcohol interlock because they can't continue working for their job if they get disqualified, and maybe too much emissions to do the limited license. But that's something to be the most mindful of. There are, however, exceptions, which is what I wanted to stress as well, is that if you don't have a car, say for example you crash your car during the drink driving accident for which you've been charged for, then you can ask the court as an exception to the alcohol interlock sentence to not to not impose one. That is one of the main exceptions, is that there's no vehicle ownership, no realistic access to a vehicle. Finances don't come into the picture on their and of itself. However, it is a situation where if you can't afford the alcohol interlock, and it's clearly by if you're on the benefit and you've got all these other expenses and things like that, then you need to put that forward to the court. But as I said, finances alone is not enough. It's not a written exception. But if you can't meaningfully participate in alcohol interlock regime, then that needs to be put forward to the court, and they can use their discretion to not impose one. But the main thing is a vehicle not being able to be fitted with one. We do see this where people have not been advised properly and they never had one in the first place. That's really good grounds for a rehearing of your sentence. However, also see it quite often is that people had a car that they had, and it ended up putting out or something like that during the 12 months, and then they can't continue with the alcohol interlock sentence. That is when you need to go and apply for a rehearing of sentence with the court. This can be done. It's quite straightforward. You have to do an affidavit and an application, but any criminal lawyer will be able to help you with that. So if that situation does arise for you, that you can't have your car puts out during the sentence that was previously fit with an alcohol interlock device, make sure you go back to the provider and get it removed, because you will continuously pay the payments as long as that device is in your car, and then sometimes it gets added on more time later, and then you're stuck with this big debt. And if you are getting your sentence reheard and it is granted, the debt still remains. That's just something you have to deal with the provider directly. So you don't want it to be a situation where you're not even using the alcohol interlock and you're still getting clocked all the payments. So keep that in mind. It needs to come out. Recently had a client who sold her car, just a cash job, because the car that she had putted out. And then they didn't change the ownership over. The person was racking up all these fines on her account, and also the alcohol interlock was still in it. So she was unable to get it taken out beforehand. So that you run yourself into some serious issues there, and then now there's a huge debt that she has stuck with, and is having to go down the rehearing of sentence. So the key issue is the circumstance at the time of sentencing, not years later. But again, the court is a bit, is generous with these sorts of applications, is that they don't want you. The court's not going to set you up to fail. They don't want you stuck with something that you can't actually continue with. So it is really important to put all information to the court, and then they can grant it if need be. I did have another situation quite a few years back where a client, English was her second language, and she struggled to understand there's a language barrier and there was no interpreter in the court when she was sentenced. So she didn't actually have a car at that time. She had to go overseas as well not long after that, and she was stuck with the debt accumulating, and her in the situation, but it was purely because she didn't understand the advice, just because of the language barrier. So all that information is really important. She got reheard her sentence, and what the court sometimes does is to backdate the interlock sentence, substitute with disqualification, and then it's kind of already run. So I've seen that before, where the person comes about a year and a half later or something after they've been sentenced with alcohol interlock, then they wish to get it substituted with disqualification because they don't have a card that can be fitted with one, and the court will backdate it to the beginning of that year and a half. So your disqualification is already over and you can go straight for a zero alcohol license. That's a really good outcome for people. So you don't have to stop, wait for the disqualification, and then, even more time is passing. So just to clarify that part, what I just mentioned about the rehearing of sentence is the most often the provision practitioners, so lawyers, look at where a person has become effectively trapped in the alcohol interlock regime. The court has power in some circumstances to cancel an alcohol interlock sentence and substitute another form of disqualification. This is a sentence commonly referred to in cases where someone should arguably never have been given an alcohol interlock sentence because they lacked access to a suitable vehicle. Lawyers should be asking these questions. Do you have a vehicle? Sometimes there's an assumption that there is one when there isn't. So always let your lawyer know that you do not have a car that can be fitted with an alcohol interlock sentence. A strong rehearing argument is when the offender genuinely met the statutory exception when sentenced. The court was not told about the exception, and the judge was not therefore invited to consider section 65AI, which is the section about the exceptions to an alcohol interlock sentence. Because again, it is the natural default sentence once you've blown off 800 micrograms per breath or you've done 2 offences within 5 years. And then there's evidence showing the circumstances existed at the original sentencing date. These aren't all, that you don't have to have all of these, but it does help if you can show that, if you can show that the exception was already there at the time. But again, as I said, some people have this issue with the vehicle coming up later. And then that's where the finances come into play, because if your car parts out, you could go get a new car, but if you financially cannot afford it, then that's relevant. So if you're appearing on a drink driving sentencing or an alcohol interlock sentence is likely, always investigate: does the client own a vehicle? Can they lawfully access a vehicle? Is there a vehicle that can be fitted with an alcohol interlock? And can they realistically afford the program? Also, just keep in mind, if you've got a really old car, some of those old cars can't even be fitted with an alcohol interlock device. So you need to tell them that if you've got a car but it's too old, I'm not sure what the cutoff period was, but some of the really old cars can't be fitted with one. But important to put all the information to the court, because when you do the rehearing of sentence, if you have to, then you need to also get confirmation from NZTA that you don't have any vehicles registered under your name, and a simple email will suffice from NZTA. So the exceptions to this is it applies where it applies, a court must disqualify the person from holding or obtaining a driver's license for the period that is appropriate under the provision relating to the qualifying offence. They can order any fine, imprisonment, assessment, or community-based sentence that is appropriate for the qualifying offence. If a disqualification is ordered, authorise the person to apply for a zero alcohol licence at the end of the period of disqualification. Typically, we see disqualifications, but again, if it's more serious offending, if there's other, factors, dangerous driving, all of that, then you may be looking at a community-based sentence. But generally, it is a disqualification in lieu of the alcohol interlock. So, an alcohol interlock, I'll just quickly run over the section that applies under the Land Transport Act, is that an alcohol interlock sentence disqualifies the person from holding or obtaining a driver's license for the period required under Section 5AE. It authorises the person to apply for an alcohol interlock license at the end of that period. Disqualifies the person from holding or obtaining any license except an alcohol interlock license, and it authorises the person, after complying with the alcohol interlock license requirements, to apply to replace the alcohol interlock sentence with a zero alcohol license, which is the same thing. You can't have any alcohol at all, but you don't have to blow into the machine. You don't have the ongoing costs. A zero alcohol license doesn't have that upkeep maintenance. Just have it for 3 years, and then once that's done, go back to a normal license where you can drink before driving, but only up to 250 milligrams, which is which is very little. Keep that in mind. So, as I mentioned, if it's over 800 micrograms per breath, then you will be subject to the alcohol interlock. Committed 2 offences within 5 years. At least 2 offences. So if you've had 3 drink driving, then you're going to be seeing the alcohol interlock sentence. Or if you opt for a blood test with the drink driving, then it's if you exceed 160 milligrams of alcohol per 100 millilitres of blood. I would say though, I do hear from my learned friends that generally always is going to be high reading if you go for a blood test. So it might be best to stick with the breath test. It doesn't show up as much. So yeah, and then just to run over the section about the exceptions, what it actually reads at is during the alcohol interlock sentence that would otherwise apply, they're unlikely to have lawful possession of a motor vehicle to the extent of it being able to use it and fit it with an alcohol interlock device, have the type of possession described in that paragraph of a motor vehicle that is technically able to be fitted with an alcohol interlock device. Also keep in mind is that if you share the vehicle with someone, so yeah, you also have to be mindful as if you share a vehicle, say you share a vehicle with your partner, and that could be an issue. So just flag that as well, because otherwise they're subject to the alcohol interlock device too. Because it's always better to have the same vehicle be driven with one. We've had people before, it's an issue when they just drive a work vehicle and that's the only vehicle they have, but they can't get it fitted with one if they've got to share that vehicle as well. But so yeah, financial circumstances can be relevant, but they're not enough on their own. If you're just purely like, I can't afford it, or it's too expensive, but you could scrape to get the money, well, that would be an issue. The court would generally look at practical circumstances, including whether the person owns a vehicle, whether they have regular access to the vehicle, whether it can be fitted with an interlock, whether they can realistically obtain a suitable vehicle, whether the costs of installation, monthly servicing and maintenance make participation in the regime unrealistic, or whether on a benefit have significant debts or other financial constraints. So, for example, a person who receives a benefit, does not own a vehicle, cannot afford to purchase one, cannot afford interlock installation ongoing fees, and has no realistic access to a family vehicle, would generally be in a much stronger argument for the exception than someone who owns a vehicle, is employed, has access to finance, but simply finds the program too expensive. The courts have generally viewed the interlock program as deliberately imposing some cost and inconvenience. So the fact that it is expensive does not automatically trigger the exception. The financial circumstances usually become persuasive when they demonstrate that the offender is effectively unable to participate in the program at all. So for a criminal law advocacy perspective, the strongest evidence is usually benefit statements or income evidence, bank statements, evidence of rent, mortgage, and living expenses, evidence that no suitable vehicle is owned or available, quotes on installation costs, ongoing servicing, and affidavits or letters explaining why family vehicles are unavailable. So the most critical, based on that, the most critical issue is what are the financial and vehicle access circumstances at the date of sentencing, generally more important than what the circumstances are now. That's basically it in a nutshell about when you are subject to the alcohol interlock device, what you need to be telling the court at the time, because it's just more of a mission for you to come back and do the rehearing of sentence later. It's going to cost you as well to get in, pay for a lawyer to do the application for you. You need supporting evidence. It's not something that can just generally be dealt with on the papers. So that is something to be mindful of. And then if you find yourself in that situation of ready and you're wanting to change it, it's always a rehearing of sentence. Because the court, they're not going to keep you, you don't have a car. Well, tough, you did the crime. They're not going to do that because they want you to be able to, move on with your life. And they don't make it too punitive in terms of, more above and beyond what the exception's there for a reason. Basically, it's like if you are in the situation, you're not stuck in that situation. You just got to show that you fit within that criteria where the court can demonstrate its discretion for imposing an alcohol interlock sentence. So that's really it, and just know that there is pathways to take with, you can always call up NZTA about some of the questions. You can call up a community law centre about some of the questions you've got with the alcohol interlock sentence. But keep in mind, if you do have a serious drink driving incident, if you have a serious drink driving incident, then this is what you'll be looking at, and this is the way to get around it if need be. And you can shop around as well for the people that install it, because there are, as I said earlier, there are different costs for different places, and some are more expensive than others. But you're looking about $2,000 a year for that whole sentence to run, and then using NZTA code for the zero alcohol license after that. But that is pretty much it that I wanted to talk about with the alcohol interlock sentences. And if you've got any questions, you can always contact your community law centre about it. We advise on the alcohol interlock sentences all the time, but just make sure that you've got the grounds to even go for it, and we can help assess that. Thank you.